Now, Chuks Oguru is a legal practitioner, and he joins me now to discuss the latest on the Rivers political crisis. Also joining me is Barrister Osigwe Momoh. Many thanks for joining me, gentlemen. Let's talk about this political crisis that has been on for months now. What is the High Court's indefinite, and this question goes to Chuks first. What does the High Court's indefinite adjournment of Governor Fubara's suit mean in practical terms for the impeachment process?
Well, let me start by saying that the shenanigans of the dramatis personae in the River State saga is rather exasperating. One expected that by now all the parties would have eaten the humble pie and sheathed their sword. But what they are doing endlessly is a sabotage of the mandate given to them by the people of Rivers State. Well, going to court is a constitutional process. And I want to say that it is within the rights of the embattled governor to approach the court for redress following the impeachment notice served on him. And the High Court had gone ahead to issue an order of interim injunction. Now, the power to issue an interim injunction is discretionary, and the law mandates the judge only to grant it after a consideration of what is judicial and what is judicious. An order of court is deemed sacrosanct and binding until it is set aside by the same court that issued it or a higher court in the judicial hierarchy. I am aware that the parties were before the same court today. And one of the parties informed the court that there's a pending appeal against the order of interim injunction issued by the High Court. And then that the matter being on appeal, the High Court can no longer proceed with the matter. The position of the law is that when there's a pending appeal, it is safer for the lower court to stay action. But that's only when the appeal has been entered in the Court of Appeal with a substantive appeal number. I do not know whether the appeal has been entered in the Court of Appeal with a substantive appeal number. If it has been entered, then it's proper and right for the High Court to stay action, to freeze into inaction until the Court of Appeal takes a decision on the matter one way or the other. But if the story is that the appeal has not been entered in the Court of Appeal with a substantive appeal number, then it was premature to stay action or to stay proceedings. An appeal is said to be entered into a Court of Appeal when the record of appeal has been compiled and transmitted to the Court of Appeal. I'm not in a position to confirm whether such has been done. But the position is that based on the matter on appeal, the High Court has taken the decision to stay proceedings until the Court of Appeal takes a decision one way or the other. And the implication is that all parties, those who want to impeach, can no longer go with impeachment.
All right, Mr. Chuks. All right, apologies for interrupting, but I just want to find out if Barrister Osigwe Momoh has a different opinion to that.
I completely am in line with, my learned brother. The reality is that the matter is definitely in court, and you don't want to muddy the water. You don't want to, start a process that will end in futility and waste taxpayers' money and waste the court's precious time. The time of the court is something that, you can't regain. And so it's a proper order. And also, in my opinion, interim injunctions are typically not appealable. It's interim. It's for a short period of time.
Okay.
The proper thing is for parties to wait and not waste time with unnecessary appeal for an interim order.
Okay, Barrister Osigwe Momoh, INEC has fixed February 21 for by-elections to fill 2 vacant seats. But how critical are these elections to the current power dynamics in the Assembly?
Absolutely everything. Impeachment is a game of number. you need a certain amount of votes to get it to go. And you need, in this case, a two-thirds majority. And so, of course, they are going to will and they're going to wish that they have everybody in their account. They need all the votes, they need all the persons. And so you do not typically want to run towards an impeachment process when you don't have the numbers. Because at the end of the day, if the numbers is not tallying, then your exercise is in futility. The lawmakers are fully aware of that, and I'm sure they are trying to amass as much vote as possible. Hence, this is in their advantage. So it's very necessary. Every vote counts with the impeachment. Impeachment is strictly a game of numbers. So impeachment is more political than legal. So when you get the numbers right, you can have it go.
All right, gentlemen, thank you for your contribution so far, but please stay with us. We want to go on a short break now, but we're not done with this conversation. When we come back, we'll continue. Many thanks for staying with us. We're still live on the news, and before we went on break, we were having a very critical conversation with Mr. Chuks and, of course, Barrister Osigwe Momoh about the Rivers State political crisis that has been ongoing for the longest time now. Mr. Chuks, does the existence of two separate appeals strengthen or weaken the governor's legal position in this case?
Two appeals. The fact remains that the governor has some respite. The position now is that while the case is on appeal in court awaiting the decision of the judex, the protagonist of the impeachment process cannot continue with the impeachment process. They have to sheath their swords until the Court of Appeal comes out with a decision. And even when the Court of Appeal comes out with a decision, any party aggrieved is entitled to take the matter to the court of last resort, that's the apex court. Until the entire process is completed, no party should resort to self-help. So whether it's one appeal or two appeals, an advantage is already conferred on the governor because his position is safe.
All right, thank you very much. Let me go to Barrister Osigwe now. Can the Assembly legitimately function with lawmakers refusing to sit due to political allegiance?
No, I mean, it can go on, definitely. The Nigerian can decide to abdicate his responsibility. And that's why the Constitution was not silenced. If you miss plenary for a certain period of time, you can be impeached. And in this case, except the lawmakers have reasons which clearly gave to say, I am being restrained, I'm being prevented from carrying out my function, so that it's not a situation like we suspect where you are tying somebody's house and telling the person start running. We suspect and that the lawmakers are being prevented because of their political affiliation, but ordinarily you can't. This is the case, the electorate back home. The constituents who sat and said they are going to vote somebody and they are being denied some by inflated egos. This is sad for the Nigerian people. But I do not think the lawmakers are intentionally refusing to sit. I think it's more like they are being prevented and being restrained and cajoled not to go into the assembly. But if on their own they elect not to sit, they are Nigerians, they can decide to say, I have taken my responsibility, of course you'll be impeached. And of course, that's another matter that will be tested in court, and the court will have very clear things on this.
All right, very quickly, let me come to Mr. Chuks. I mean, I was going to buttress that, but because of our time, Mr. Chuks, does the lack of full representation affect the credibility of an impeachment or legislative action?
The Constitution, the supreme organic law of our jurisprudence, has wisely, or the framers, delineated Rivers State into about 31 or 32 constituencies. The Constitution has also set a number that will form a quorum. And legislative duty is a mandatory constitutional obligation. So where somebody who is supposed to be representing a constituency abdicates his responsibility, then there's a problem. For the legislature to function effectively and constitutionally, there must be full representation in the sense that the quorum prescribed by the Constitution is met. Anything done outside the quorum is unlawful and unconstitutional. And we have seen all that play out in the judgment that was given by the Supreme Court in a case where only 4 members of the Rivers State House of Assembly sat to pass the budget of the state. So full representation, meeting with the quorum as prescribed by the Constitution is very, very important.
All right, thank you so much for that, Mr. Chuks. And to Barrister Osigwe now, with the Court of Appeal now expected to weigh in, what key legal issues will likely determine the outcome?
Court of Appeal, I think the focus the court will most likely have in this regard is a matter of facts. Yeah, they are going to look at the matter and wonder if indeed the questions that have been raised now, does this delve into the gross misconduct? It would have been easier if they had tried to bring, in my opinion, the former charge of destroying the state complex and that being so intolerable and distasteful, and that is the reason why they are constituting this impeachment proceeding. That's likely what's going to happen there. But if it was centering on the issue at hand, which is the impeachment, which is the interim order, whether or not it ought to stand, I think that would be really waste of our time, because the court will definitely side, in my opinion, with the Court of Appeal side, with the High Court, to say on this issue, before, we're not even looking at the substance. The interim question here is whether or not the court can give this order to an interim order, and whether or not it will impeach that order. And I think, of course, they won't want to impeach the order. The courts generally allow the High Courts to exercise this discretion judicially and judiciously. And it's a waste of time to start appealing an interim order, because by nature it's very short. And this is what they have tried to do. They have taken us all the way to argue whether the order ought to be given. Whereas the proper thing to do is to wait 7 days, 14 days, and it's over. So I think this is a waste of time. If that's, of course, that's the question that they have there. I am not aware of any other issue. But for the substantive matter, driving left, right, and center, because I think the other matter dealt with the substance. And the substance of it is still a waste of time. This is political. Almost everybody can smell it from afar. It has really no roots in legality. There are no real questions of law here. It's just a political charade and a waste of our taxpayer time. This is where I'm coming from. It's wasting our time, wasting our money. The states of rivers are likely to be ungovernable because two adults cannot deal with their egos and manage the resources properly. We ought to see it for what it is. This is not a legal issue. This is an annoyance on the river people and the Nigerian people by extension. You are wasting our time, wasting our resources. We have refused to govern the state because a godfather or a gentleman who believes a godfather wants to decide the fate of the people. I think the court will see it for what it is and not even waste time with the frivolous nature of the matter in its entirety.
All right, thank you so much, gentlemen, Mr. Chuks, and of course, Barrister Momoh, for joining in and weighing in on this very important conversation.